Whose furry is this? Whose furry is this?
Council, along with the people standing behind me for the plaintiffs in this case. And of course, as I'm sure those of you who've had a chance to read the judgment, we're of course very pleased with the decision of the court. The court found that taking away people's ability, medically approved patients' ability to organize for themselves as counsel, along with the people standing behind me for the those of you who've had a chance to read the judgment, government's move, of course, very pleased MMPR in doing the decision of the court arbitrary. The court found that taking away were a number of people that fell through the cracks, either because Judge Manson picked two dates, one for production, September 30th, 2013, one for possession, the date of his judgment, March 21st, 2014. And so some people, while their production licenses were valid, their possession licenses had lapsed. We've told people they should go back to their doctors and get an authorization from their doctors to cover their possession. And that's the interim position. But so we need to have the people who fell through the cracks need to be addressed. And we've also had a large number of people who need to move their production licenses, and they've been unable to do that under the frozen circumstances that exist. We've had people who've had landslides that impacted their production site, so they had to physically move. We've had people who landlords gave them notice, people who got married, people got divorced, any number of different things. So we're going to need to have or try to get the government, or if necessary, go back to the court to hopefully fine-tune that injunction until we see the final product from the government.
Did the court give any guidance for going forward?
Well, it made it clear that the MMPR did not promote health and safety. The government found that many of the issues like mold, fire, all that stuff that they raised was not substantiated, that it was all remedial and could be done safely and securely. So I think to that extent the court has set out findings on the evidence given by the police, the evidence given by some of the fire commissioners. In fact, the court found Corporal Holmquist and Fire Chief Len Garris to particularly be not credible witnesses in the case. And so, there was a considerable overstatement. So hopefully the new government will see that this is an opportunity to re-legislate quickly to enable medically approved patients to produce for themselves or have a true caregiver stand in their shoes and do so for them. It still leaves the question of the dispensaries and the compassion clubs. And as we know, and the court actually comments on the ineffectiveness of the MMPR, the new regulations, and comments on how there's now been this huge increase in the number of dispensaries. And our take on that is that the patients that we are representing were mostly people on disability pensions who couldn't afford the prices of the LPs or the dispensaries in any event, and determined that they could produce inexpensively for themselves. The great majority of people, obviously, though, don't necessarily want to produce for themselves. They want to be able to go somewhere where they can talk to somebody, get some advice, get some information, and decide what to purchase. And the place where people do that are the dispensaries and the compassion clubs. The MMPR model doesn't allow for that. And so the government needs to pay attention to that. It needs to see that, sure, we need people who are licensed producers like they have under the MMPR who can produce maybe on a large scale basis in large quantities, but we also need independent dispensaries and compassion clubs who can then provide the information to the patients and let the patients make that choice as to what they want to do and simply be able to purchase it much as if they would go to a pharmacy or something like that for any other drugs. So hopefully within 6 months we will have a reasonably regulated system that hopefully provides that solves the problems for everyone.
John, with respect to enforcement, particularly outside of the Lower Mainland, throughout British Columbia, what might law enforcement draw from this ruling today when it comes to enforcing the current regime, which I guess technically is still on the books?
Well, I think we're in the status quo at the moment because the declaration is suspended. So if the police are investigating a production that they don't know whether it's legal or not, the process is that they phone Health Canada. The Office of Medicinal Cannabis has continued to maintain the 24/7 line for the police to call. So, and they would take notes and give them information and so on. And so the database is frozen. They call up the database to determine whether that address is in fact in the old database or not. And if it isn't, they put that in their affidavit and seeking their warrant to go in and search. So hopefully something will be done to address that soon, and particularly in those cases where the person's possession license had lapsed and they went to their doctors and they got an authorization under Section 53 of the Narcotic Control Regulations, which is the general power to prescribe that doctors have in relation to any narcotic for a patient who they're treating. And hopefully the government will recognize and that those people will be left alone as well, so that the police will, or that the Office of Medicinal Cannabis will ask the question, well, have you determined if they have a Section 53 authorization or not? And hopefully the justices of the peace to whom these applications are made will ask that question. Just because their possession license lapsed, have they been back to their doctors? Do they have something else? Have you checked that out? Hopefully they'll do that before barging in and invading people's liberty and the security of their person.
John, Justice Phelan said that a couple of the government witnesses, their experts, their testimony was shredded. He pointed to a lot of bias in their testimony. Do you think that just points to the stigma surrounding this substance?
Well, I think he said that particularly in relation to Fire Chief Len Garris from Surrey. He found him to be particularly biased and not credible. And he said similar things with respect to Corporal Holmquist. And the young lawyers standing behind me are the ones who did the cross-examination of those two witnesses. And so I think you can give them kudos for having picked apart the evidence, particularly from those two witnesses, to show that it simply wasn't credible. That, you know, all of these allegations about mold, fire, home invasion, public safety, are all things that can be dealt with and dealt with reasonably. And their focus was on illegal operations, not legal medical operations. They had virtually no evidence to support those types of problems in legal operations.
John, I think the decision mentions, the examples are brought in from other countries in terms of schemes. What kind of scheme might we be looking at 6 months from now that kind of incorporates, the needs of your clients and, license producers the system?
Well, hopefully they'll go back and look at what they had under the MMAR, the Medical Marijuana Access Regulations, which allowed people to produce for themselves. In my opinion, they don't need to be as overly restrictive in terms of regulations. Unfortunately, the word marijuana still conjures up this emotional response amongst some people. But you need to remember that, doctors prescribe all kinds of drugs that kill people. And we have a serious problem in relation to the opiates. And when they cut those people off, they go to the street and they end up dying from overdoses of fentanyl. I've seen in pharmacies statements that are posted saying that 80,000 young people got high last year taking their parents' drugs from their medicine cabinet. And the government simply says, make sure your medicine is locked up. Make sure you keep it away from your children. We know that people can grow tobacco 15 kilograms for your own use and the use of anybody over 18 in your house. Tobacco can kill. We know people can make alcohol, spirits, beer, and wine in their premises. So, these are drugs that can kill or cause serious health problems. As the judge found and repeated, there's no lethal dose for cannabis. Sure, you can take too much, especially edibles, and feel uncomfortable and so on, but you can't die from it. And so, let's put it in context and realize that we've had compassion clubs and dispensaries here in Vancouver for going on 20 years. Do we have a fallout in terms of problems from those clubs in terms of medical use? No, the evidence is virtually non-existent.
But in terms of the scheme that the government has to revisit or look at, I think that the decision also mentions the cost of the MMAR type scheme. I'm just asking how you envisage it might be run.
Well, I think, we have experience in terms of how it was run over 10 years. And we did not have significant problems from legal medical grows over those 10 years. The problems, again, that the government and their witnesses focused on were illegal operations. Operations that cut corners, that didn't get inspected properly, that didn't make sure that it was safe for them and for their neighbors and other people in the premises. So, I think it's not that complicated to have a legal regime. You don't need to have inspectors, a huge team of inspectors, to go in and inspect everybody's premises constantly. You have municipalities and cities that have inspectors that check for all kinds of things in terms of houses and buildings and so on. So there's no need to sort of reinvent things in order to reasonably regulate the production of cannabis.
John, you'd wanted it to be regulated as a natural health product. The judge kind of dismissed that notion.
Well,
where do you see it going?
He actually pointed out that he makes actual specific reference to the natural healthcare product regulations. And as he points out, the only reason cannabis doesn't fall within those regulations is because it's set in Schedule 2 to the Controlled Drugs and Substances Act. Mr. Trudeau his government could, exercising Section 56 of the Controlled Drugs and Substances Act, simply pass an order in council from the cabinet removing cannabis from Schedule 2 to the Controlled Drugs and Substances Act. The minute that the government did that, arguably the natural health care product regulations would cover cannabis for medical purposes. So you'd have the MMPR, which is suspended, but you'd have the natural health care product regulations, which would fall into place. In my opinion, it still remains that doctors of naturopaths, herbal doctors of traditional Chinese medicine today know more about this type of whole plant medicine than our regular physicians.
Looking back a decade from now, what will you think you'll be saying about this ruling?
Well, a decade from now, I'll be really getting up in years, so hopefully I'm still here to be able to see, I hope, a reasonably regulated market that satisfies particularly all medically approved patients.
Does this strike a blow for the commercialization of the industry in the drug?
Well, I think that if we're able to have a reasonably regulated market for medical purposes, that will help to show what can be done in terms of a social market as well. I mean, there are different issues involved, and people need to not think that simply legalizing cannabis will sort out the medical issue. There are issues in Colorado and Washington State that have legalized in the U.S. where some of the medical patients have been prejudiced by the legalization because of the various restrictions and limits. You have to appreciate that a medical patient, it's based on a particular medical condition and what works for those patients, and that isn't necessarily, some of them, they need larger doses than others. So, it's hard to know exactly what a legal social regime will look like, but importantly, it should not interfere in any way with the medical regulation.
And one last one. A large part of the case hinged on the hiccups faced by the MMPR as it first came into place. It's expanded quite a lot since then. What do you make of the current state of the MMPR in terms of patients?
Well, again, I think Vancouver is the illustration. We went from maybe 10 or 20 compassion clubs and dispensaries to the last figure I think I saw was over 150. And while Vancouver City is trying to regulate them in terms of zoning and licensing, that, in my opinion, is evidence that, and I think the judge refers or hints at that in this decision, is evidence of, as I think I said before, people voting with their feet and saying, we've gone to the LP, maybe we got it the first time, we're on a waiting list, we can't get it now, so we're going to a pharmacy or equivalent of a pharmacy, and we're going to be able to talk to somebody there, we're going to be able to see the different types of cannabis, and we're going to be able to try the different types of cannabis. As I said, I think the great majority of patients would like to be able to go to something like that. So I think what really needs to happen is the government needs to look at the MMPR and the LPs and the dispensaries and come up with a regime that takes all of them into account while at the same time allowing patients to produce for themselves or have a caregiver do so for them.
Thanks.
Sorry, a licensed producer under the MMPR, Marijuana Medical Purposes Regulations.
How are your 4 plaintiffs feeling today?
I think that they're ecstatic. I saw one of them here a moment ago.
Right behind you, John.
There he is, Mr. Davey. I know I spoke to Mr. Hebert on the phone as well, and he might be here. So I'm sure they're very, very pleased. But remember, they were representatives. We picked them from a huge group of people to make sure that the different types of situations were covered, because this was a constitutional challenge. If the constitutional rights of any of them were impacted, so are the constitutional rights of all others who fit within their category of medically approved patients. So not only are they very pleased, but I'm sure that there's about 28,000, perhaps more out there who are also very pleased. But we still have to be concerned, very importantly, for all of those other medically approved patients who fall between the cracks and who need to have their situation addressed. They are medically approved patients. Their constitutional rights are continuing to be violated until that is solved.
You can have a word with me if you like.
Come up to the...
Oh, right up.
Share your reaction today?
My name is Sean Davey.
Sean Davey,
Sean
one of the
Davey.
plaintiffs.
Yeah, one of the plaintiffs.
What's your take on the ruling today?
I think it's great. I see it as a good thing. So yeah, that's a good thing altogether. So
Yeah.
Still gotta wait 6 months.
yeah, but I can't wait 6 months. But I mean, yeah, it's good. It's on the way. It's on its way. So that's it.
He doesn't have to wait 6 months because he's covered by the injunction.
Yes.
As the court did say, the injunction continues until further order of the court. And I say, unfortunately, there was some people who fell through the cracks, so we may need to address that. But he continues to be covered under that injunction.
Yeah.
Can you tell us a bit about your situation and what got you involved?
I was hit by a Dodge 1-ton truck at about 120 kilometers an hour on the motorcycle, and I was in a coma for 3.5 months and told I wouldn't walk or talk in. I was prescribed $6,000 a month medications. When I took myself off, marijuana has helped me 110%, and there's nothing that I would take any other. That's it.
So here's an example of a person who suffered a severe brain injury in a motor vehicle accident, who now manages to succeed using medical cannabis and to not use a whole huge variety of pharmaceuticals that he otherwise had to take.
And they make me feel like nothing but crap. So this makes me feel like heaven. That's it. So
Why do you grow it at home? Why is that important to you?
because I use too much of it to have to buy it from anyone else. And what I want is I want the exact product that I need. So there's over 3,000 different strains. So you never know what you're getting until you get it, right? Unless you grow it yourself. So
There's a very good analysis in the judgment of each one of the plaintiffs and their circumstances, and particularly getting into the costs affordability issue. So, and Sean was an example where the court found just how problematic it would be for him to try to have to buy what he requires from a licensed producer under the MMPR.
So Sean, how much do you need to use?
I use up to 2 pounds a month. So, and so I'm mainly cooking. 10% of it's smoking, and 90% of it's all cooking. So, yeah.
As the government goes forward, how important is that cost element to this? The expense of making sure that people who need medicine get it at an affordable price.
Well, it's very important, but it's not the only issue. I mean, we certainly demonstrated that many patients could not afford the proposed then LP or licensed producer prices, and the dispensary and compassion club prices are often the same. And many of the patients are on disability pensions, and so they don't have a lot of money. And so they determined that they can produce it relatively inexpensively by producing it themselves, and especially if they can have it outdoors for a period of time to eliminate the hydro cost. The hydro cost is the biggest cost factor for people. And so, but it's not just a question of affording it, it's also a question of knowing what's in your medicine, being able to control what's in your medicine, and being able to determine what works for you. You have that choice as a patient, as opposed to being simply dependent upon whatever the licensed producer or the dispensary might have available at the particular time. This ensures a continuous, regular supply to a patient producing for themselves.
That's it.
Mr. Davies, how much money will you save by being able to grow at home?
If I was to have to spend it on myself, I would have to spend about $6,000 to $8,000 a month in medication. I couldn't do it. So yeah, that's it. I mean, when I grow it myself, I roughly spend about $500 a month for hydro and plant needs, but that's it. So huge difference, right? And I know exactly what I'm getting out of it. You're getting exactly what you need, and that's it. So
How do you spell your name, sir?
SHAWN
Davey?
DAVEY.
Any other questions?
John, how does this, going forward with the Liberals' legalization for recreational scheme, will this have a heavy effect on whether or not home growing might be in that? Is there anything in the ruling that would, on a constitutional basis, kind of push that into the recreational side of things?
It's hard to take some of the things from this ruling and just apply it generally to the social use, because don't forget, we're talking here about health and public safety in terms of the patients. But I think it's pretty obvious that if the court has accepted that the evidence the government was putting forward about mold and fires and all of these concerns, and finding that that evidence just didn't hold up, and that it can be done safely in various different ways, surely that would indicate to the government that if they're considering legalizing, taking it out of the Controlled Drugs and Substances Act, stopping the use of the criminal law, we're then going to have hopefully legislation that's federal. We'll also have provincial legislation, and we'll have local government involved. And because it's legal, it will be above board. Hopefully people will get proper inspections, make sure that everything is done safely. And so I would hope and expect that in a legalization model that will continue to be permitted. There'll maybe be limits on the numbers of plants and things like that. But I would hope and expect that in their legalization model, they learn from the evidence in this case going forward.
There's a lot of companies and business people across the country sort of look at the marijuana market, whether it's medicinal or recreational, dollar signs in their eyes. What does this decision say to them in a way? And is there anything they can take from that? And going forward, how you deal with the business of this?
Well, I think we have to remember that cannabis is obviously the most popular illicit drug in the past. But also remember that 80% of the Canadian market was our neighbors to the south. Even though it may have been only 5% of their market, it was 80% of ours, according to the figures that I've read. So that market is disappearing, or has disappeared to some extent. And things are evolving in the U.S. Fairly rapidly in terms of not just medical use, which is now in excess of 30 states, but also in terms of legalization. So I think people who think that there's a huge amount of money to be made first need to temper their views, realizing that the Canadian market is much smaller than what it would have been in an illicit market. Nevertheless, I mean, this only addresses medical. And, you know, it went from small numbers to 38,000 by March 31st, 2014. And I'm told that even under the MMPR, there's now 40,000 patients registered there. So there's a huge interest by patients in how cannabis can help them, and help them without the use of the other drugs. So it's going to be interesting to see how that changes, whether the demand increases exponentially because people realize that this can be used by them and they can still have good quality of life and not feel zombied out by the powerful opiates and things of that kind. So, you know, I think that there certainly will be money to be made by businesses and people. There'll be a demand by people. As I say, they don't all want to grow for themselves or have a caregiver grow for them. So I think that's the area where there'll certainly be opportunities for businesses to hopefully provide good quality cannabis to the market.
The pharmaceutical industry is not noted for altruism, though, right?
No, but here we have, you know, people who are producing cannabis, and we have people involved in the dispensaries and compassion clubs who have been doing this to try and make sure that patients get their medicine. So hopefully there'll be a demonstration of some altruism, but only time will tell.
Mr. Conroy, where does this judgment of this morning fit or doesn't fit with the intention of the Liberal government to legalize recreational marijuana?
Well, as we said a minute ago, I think it gives them an example of how it can be done for medical purposes, and to take that into account when they're trying to decide how to go about legalizing. I mean, legalizing means stop using the criminal law, but that also then immediately means that there'll be a role to play for the federal government, as they do for alcohol and tobacco in the Excise Act, the provincial governments, as they do for liquor and tobacco, and for local governments, particularly in terms of people's production. Well, as we said a minute ago, I think it gives them an example of how it can be done for medical purposes, and to take that into account when they're trying to.
With the intention of the Liberal government to legalize recreational marijuana?
Well, as we said a minute ago, I think it gives them an example of how it can be done for medical purposes, and to take that into account when they're trying to decide how to go about legalizing. I mean, legalizing means stop using the criminal law, but that also then immediately means that there'll be a role to play for the federal government, as they do for alcohol and tobacco in the Excise Act, the provincial governments, as they do for liquor and tobacco, and for local governments, particularly in terms of people's production or, you know, licenses to distribute, those sorts of things. So I think you'll see all three levels of government in there, and all three levels of government reading this decision and seeing that many of the fears that were put forward were totally overblown, and that they don't need to be so worried about regulating. It can be done on a reasonable basis.
Would it be a good idea to have one single law for both medicinal and recreational marijuana?
No, I think they have to be separate, because there are separate issues that arise in relation to social, recreational versus medical. And I think Colorado and Washington State actually illustrate that if you look into what's happened there.
John, one last one.
judge touched on blue boxes and that issue. Do you think it would be just if the government mandated that home growers or small-scale producers have to have a unit like that?
You know, I would be really surprised to see them do something like that. But at the same time, I think, you know, there are people who have fears if they live in apartments or condominiums or restricted spaces. And certainly the Bloom box and variations of the Bloom box do provide an engineered solution to address those concerns. So that people who may be in those types of accommodations could do it and do it safely, not impacting their neighbors, because the fire, electrical safety, all of that's taken care of, instead of people making major modifications to their apartments or basement suites or whatever it might be. So I think there's some value in the existence of those units to make it easy and safe for people to produce. All right.
Good job, bud.
Thank you.
Good job.
Well,
Yeah, all you guys.
these guys
Good job,
too.
man. Yeah.
So the next fight is making sure the dispensaries are legal.
That's right.